So today we're going to discuss about the new intermediary rules that have been introduced by the government as an amendment to the Information Technology Act. I'm sure all of you would have read about this in the media, in news, seen this in news. There was a lot of hue and cry about, these regulations are violating fundamental rights, freedom of expression, etc., etc. But before we actually go to what has changed now and what is applicable, it is important to understand why this was introduced and why these rules were brought in place. So I'll probably just spend 2 minutes to kind of give a little bit of background and history as to India's information technology and data protection regime. So until 2007 2008, while the IT Act was enabled way back, it was kind of a pretty much a toothless legislation where intermediaries being platforms had no real role to play. And there were very few compliances or very few activities that they were really responsible or liable for. Increasingly, what has happened in the last few years is the penetration of digital media across platforms, across consumer space, across people, across sort of geographies in India has significantly increased. What that has led to in the last 5 7 years is instances of fake news, news not being authenticated, which has led to political issues, which has also led to communal riots, and all of this because the platforms that were actually putting this up for the consumption of their consumers were largely unchecked, and they did not really have any liability under the regulations. So effectively, and as all of you would know, most of these platforms, Twitter, Instagram, Facebook, all of these are based out of India. So they don't really have, while they have an Indian entity, but the parent company is all based out of India. So they didn't really have a liability or sort of, any sort of say in India if there were these issues. So what the government thought, and actually they took a leaf from this from developed countries like Singapore, where there is a balance between self-regulation and government intervention. This is a very tight line that the government had to kind of draw, because if there was over-regulation on the platforms, it would kind of be borderlining violating fundamental rights, taking away freedom of speech, etc. So what they did was find a balance and draw up a self-regulation mechanism and make the intermediaries liable and accountable. The idea was to bring more accountability to the platforms which were earlier not really having those obligations upon them. Basic obligations of due diligence, etc., were always there. But there were never obligations that they had to appoint grievance officers, had to set up separate sort of nodal agencies or platforms to monitor the content going on. So that was the brief idea, and it's a legislation that's going to bring about a lot of change. As digital India grows, it's going to kind of become more and more stringent. There is going to be more and more government intervention, but I think this is, personally, according to me, this is the step in the right direction. It makes platforms more accountable, and most importantly also ensures that there is some sort of accountability of the content that people are viewing. It is not content that is unchecked, which can lead to several issues like I just said. So I will let Suplab take a deep dive on the regulations and walk you all through what has changed and what is important now from an intermediary perspective, what they need to keep in mind. Thanks. Suplab, go ahead.
Yeah, thanks, Jayesh. That was an awesome introduction, actually, and pretty much sums it up how it is happening in India as of today. And before I start with my PPT, Jayesh, as he rightly said, like today, every day we open newspaper, we see the government horns locked with the intermediaries. Every now and then there's a fight going on with Twitter, and pretty much everyone is like, what is happening? What is so much there in the rules that they are finding it so hard to comply? And yeah, so having said that, I would like to begin with this quote that which Supreme Court in the Delhi riot case had said, quoted that while social media platforms have played a crucial role in enabling free speech by providing voice to the voiceless, we cannot lose sight of the fact that they are simultaneously become a platform for disruptive messages and voice and ideologies, which is very much true because every other day we see social media companies like Twitter or Facebook, locked horns with the government, and there's some dispute or the other going on between the two. While one seems to be fighting for your free speech, the other, that is the government, is continuously concerned about national security and uh, fake news. So nowadays, if you see, there's a paradigm shift in the role of an intermediary in our lives. Earlier, it used to be just a conduit where you send an email over Gmail to another person and the person receives it, and the role of Gmail is limited to that. But nowadays, if you see these social media companies and the platforms they run, they determine who should be viewing what, how the algorithm will work with or without human intervention. That's a secondary thing. But uh, basically, they determine who should be viewing what and to what extent the a particular content that is displayed on their platform should be targeted to. So given all these cases, Supreme Court is not totally wrong that, um, while it's a flag bearer of freedom of speech and expression in many ways, but we cannot ignore the fact that there are riots happening or there are fake news or acts of violence which are arising out of elements that come out of these social networking. So this entails for a more developed approach towards social medias and toward these social media companies, because this has been going on unregulated or mildly regulated for a very long time. So let's see what's the next year. So to begin with, what is an intermediary? First, to begin with, intermediary has been defined as any particular electronic record means any person who on behalf of another person receives, stores or transmits that record or provides any service with respect to that record, and includes telecom service provider, network service provider, internet service provider, web hosting service provider, search engines, online payment, online auction sites, online marketplaces, and cyber cafes. Now, if you see that I have highlighted a portion of this definition, that's because when IT Act was introduced, the definition of intermediary was limited only to mean a person who's transmitting and assisting in transmitting a particular record, electronic record. However, later on it was realized that the definition was too narrow and could be interpreted liberally, especially with the rules which only give protection to the telecom service provider. Therefore, this spectrum of examples were added so as to show the how wide the definition of intermediary is and like what all it can include. And if you can see, it includes from your telecom service provider, which is like Airtel or a BSNL, to even cyber cafes on your locality as intermediaries. So before I jump onto the topic, I would like to highlight issue that still prevails, unfortunately, is that whilst the definition of intermediaries includes such a wide spectrum of uh, entities, a categorization of entities has still not been done under the new rules, Intermediary Rules 2021. That's big, and that's quite unfortunate because the kind of intermediaries that we deal with day in, day out are quite varied, and their roles and responsibilities are completely different. So the first step to my understanding should have been that create a distinction between these kind of intermediaries and then move on to the next step of legislating it. Okay, so now coming to the next portion of the topic is that the kinds of legislations that there are in the world about which are regulating intermediaries. First is the strict liability model, which is typically followed in China and Thailand. That is what the intermediary has to take 100% responsibility of the content displayed on it. No, regardless of the fact that the person who is uploading it, the content that is getting uploaded, irrespective, the intermediary has to take charge of the entire situation. the safe harbor model, which is like a fine line between a broad immunity model and a strict liability model. The safe harbor model is simply put means that when an intermediary takes some reasonable diligent steps to ensure that their platform is safe and is not being misused, they will get some sort of a protection under the law. And basically, to simply put it, if the intermediary does not determine who the end user is, does not interject or amend the message that or the contents and such, but basically the involvement, if the involvement of the intermediary is minimal, it will get immunity under the law. That is the safe harbor model. And then we come to the third category, which is a broad immunity model, where basically the intermediary has zero liability on what is being transmitted through it. It's just a conduit. And there are laws in US and UK which give intermediaries broad immunity, and their responsibilities literally zero to none. Okay, now India has developed its law on intermediaries on basis the safe harbor model. And when we speak about safe harbor model, the first thing we should be discussing is the Manila Principles. So, like any other international conventions, a set of individual bodies came together in Manila, Philippines, and they determined the basic parameters that should be there in a safe harbor model of law. And the reason, and this was in consonance with free speech under United Declaration of Human Rights and such other international principles, so that free speech is given primary importance when it comes to intermediaries, and intermediaries don't shy away from their responsibilities because there is an ambiguous legislation in place in any country. So in order to bring all countries which are following safe harbor model in line with certain principles, this principles was developed and was circulated. First is intermediaries should be shielded by law from liability for third-party content. So Facebook should not, simply put, an entity like Facebook should not be liable for what you and I put together in and display on Facebook. First. Second, content must not be required to be restricted without any order of judicial authority. Now, why judicial authority is very important. So see, if we go back to our administrative law, then not every authority should have the right to do JUS. That is, what is right and what is wrong should be determined by a judicial authority. And if you clearly notice, it doesn't say that it has to be a governmental authority, it has to be a judicial authority. However, under Indian laws, we have seen that laws have been developed to restrict contents on Facebook or other social media like Twitter, basis orders from even governmental authority or administrative authority. Now, this is a shift from the Manila Principles. Third, request for restriction of content must be clear, unambiguous, and follow due process. So laws should be clearly laying down as to what is restricted and what cannot be there on the intermediary platform, and what can be there or what needs to be taken down once such things are uploaded. And law needs to be very clear on this approach. Next is law and content restriction orders and practices must comply with test of necessity and proportionality. Now, anything and everything cannot call for a blanket ban. You cannot ask intermediaries to put a blanket ban on something because it is because one person or one content has breached a particular law. So it has to be necessary. Whether it is necessary, first thing needs to be seen is whether it is necessary, whether it is proportionate to bring down such content. And last is transparency and accountability must be built into content restriction laws and policies and practices. So there has to be absolute transparency, because see, as much as it is the responsibility of the government to ensure national security and compliance with laws, it is also important that people have their free speech. So if you imagine you tomorrow want to voice your opinion on something and your government doesn't like it, and you see tomorrow your post has been taken down without any sort of clarification or explanation as to why it has been put down. It's a sheer lack of transparency and accountability. So laws needs to be framed as per Manila principle. Laws need to be framed in a manner so that there is absolute transparency as to why a content is being taken down, and is there the law backing it, or some kind of reasoning basically, which holds the social media intermediary accountable as to why some contents are restricted. Now, let's take a quick look at the jurisprudence of intermediary liability and how over years it has changed. So first we come to that pre-IT, pre-Bazi.com time of IT Act 2000 when it was developed. And as I had told you, the definition of intermediary was very simple. It just mentioned someone who is assisting in transmitting the messages from one end to the other, like postman, and has no involvement into what the contents of the letter that the postman was carrying. And the rules that were there back then would give only protection to telecom service providers, and didn't include entities like other social media enterprise, like those e-commerce website or social media platforms or Google. Protection was not given to them, and it was only the telecom service providers who were given protection. Then came the case of Avnish Bajaj versus State, where an MMS from Delhi Public School was put up on sale on Bazi.com on Friday. It stayed on till Saturdays and Sunday until Monday, and no one could put it down. And what happened is the police authorities arraigned the CEO of Bazi.com, Mr. Avnish Bajaj, for selling pornographic materials on the Bazi.com platform. Bazi.com was back then a subsidiary of eBay. So, however, the case proceeded with Mr. Avnish Bajaj being also prosecuted, but somehow they didn't make Bazi.com, the company itself, a party to the particular suit. So that case went on up to Supreme Court, and then Supreme Court says no, you cannot arraign a particular CEO of a company without arraigning the company itself, and the proceedings was quashed. But what was realized that Bazi.com had particularly no role to play in the entire scenario. It should have been ideally given protection under the IT Act because it is a mere conduit, and it had done in its diligence whatever it could to take down and take necessary action. Then why prosecute someone for something which they have not done? And this was realized, and this immediately after that the IT Amendment Act came in. And as you can see in our previous slide, the definition of intermediary was the scope of the definition was increased, and then the safe harbor and principles were built in as per Manila principles, that the intermediary should not be held liable if it had not initiated a particular transmission of a particular content, intercepted the content, or determined who the end user has to be. It'll also, there are other protection that was built in. The intermediary was not supposed to act in a malified manner, and only then it will be entitled to protection. Also, the intermediary was required to follow some kind of due diligence, and the definition of due diligence was for the first time was built in the 2011 intermediary rules later on. Then came the case of Shreya Singhal versus Union of India, and the question that arose, and many of us know Shreya Singhal case as the case which brought down 66A of the IT Act for free speech, but there are other sections which were also put to task and were determined upon by the Supreme Court in the case of Shreya Singhal versus Union of India. And one of the section was also section 79 for condemning free speech and expression. Supreme Court said that not anyone and everyone's voice can require a social media intermediary or an intermediary for that matter to take down a particular content. it has to be a judicial authority issuing a notice to the intermediary to take down a particular content. So this particular change the definition of knowledge under the IT rules. What does that mean? That means that, see, what the IT rules say, that the intermediary should have knowledge. If it comes to the intermediary's knowledge that a particular content needs to be taken down, then the intermediary has to immediately and with prudence take down the particular content. Now, question arose, and that what does this knowledge mean? Does it mean that any person like you, me, XYZ can come to a social media intermediary and ask them to take down the message? Or can it be a government body, administrative body, or does it have to be a judicial authority? Shreya Singhal said that knowledge means actual knowledge, and by actual knowledge, it means that the social media intermediaries has to be informed or intimated to take down a particular content only by a court of law, and only then it can be considered as actual knowledge under IT rules 2011, and only then contents can be taken down. Now, this is what we see and end of an era where the liability of an intermediary became restricted to only certain cases. Now comes the third phase, where people started realizing that the role of social media intermediaries is not just a conduit, especially courts started realizing, and they have much more responsibility to take care of. And therefore, we see the case of MySpace Inc. versus Super Cassettes, where the court said that, okay, knowledge can be classified as actual knowledge, and you are required to take down only when a court asks you to do that. But if it comes to your specific knowledge and IP or intellectual property or a copyright has been infringed, you'll have to take down immediately, and you don't need court's order for that. So you see, a shift has happened from just mere knowledge to actual knowledge to now specific knowledge, where a court order was no longer required to take down particular content. Then we come to the case of Christian Louboutin versus Nakul Bajaj, and these other cases, Sabu Matthew George versus Union of India and Kamlesh Vaswani versus Union of India and Ray Prajwala case, where contents were required to be proactively filtered by the intermediaries, and no court order was required for that, because according to the court, it is clearly laid down the law requiring an intermediary to take down these particular kind of contents, say something related which is violative of the Prenatal Diagnostics Act, or the pornographic materials. The court, according to court, the social media intermediaries or intermediaries in general did not require a particular notice to let them know that these contents are illegal, and these should be proactively monitored by the intermediary itself and taken down. So that's what we come to. So we see the responsibility of social media intermediaries were over a period of time through cases increased to a certain extent. Next is, let's see a synopsis of the 2021 rules. First is the due diligence requirement of intermediaries, which is kind of like a smooth flow from 2011 rules, except that it has been made a little bit more robust, the kind of due diligence that an intermediary needs to take care of before, ensuring that it has absolute protection under the law. Then what is new under the 2021 rules is the additional requirements that a significant social intermediary needs to take care of. And by significant social media intermediaries, we mean that intermediaries which has more than 50 lakh users are categorized as significant social media intermediaries, and the kind of due diligence that they need to entail is much more robust compared to what a normal social media normal intermediaries needs to be taken care of. Third is the code of ethics, procedures, safeguards for digital media, that is OTT and news portal needs to be taken care of. There's a code of ethics that is annexed along with the IT 2021 rules, and these kind of platforms like OTT platforms and news portal platforms required to adhere to such code of ethics. Fourth is the grievance redressal mechanism for digital media. Although all social media intermediaries are required to have a grievance redressal mechanism, but the one which has been set up for OTT platforms and news portals are much more robust and layered. Like there'll be a, grievance redressal mechanism at the entity level. Then there will be a union of or a communion or a committee which has to be formed by combination of all these OTT platforms and news portals. And then third and the last one is at the Ministry of Information and Broadcasting level. Last is the registration of news and current affairs publishers with the last part will deals with furnishing of information and registration of these news and current affair publisher with the Ministry of Information and Broadcasting. Now let's do a detailed analysis of 2021 rules and how it has been promulgated. So first, to begin with, for normal intermediaries, there are certain number of details which is expected that the intermediary will publish, and which includes a robust privacy policy, terms of use, and a notice to the users on a timely manner that if you don't follow to these adhere to these privacy policy and terms of use, then your content must maybe taken down. Also, compliance reports, whatever the social or the intermediary has complied with, the report has to be furnished on an annual basis by the social media intermediaries, and certain intermediaries have already started following it, like the Facebook and Google have already started following. It has started publishing compliance reports. Then furnishing of information to government, there are certain information which is required to be presented within the time period that is mentioned in the legislation, which is generally within which ranges from say 72 hours to 180 hours upon receipt of notice. The intermediary is required to furnish the details that is sought by the government under certain typical cases, which has been under various circumstances. And then preservation of record. So immediately after a particular record has been taken down, it has to be stored for a particular period of time before it is completely deleted from the system of the intermediaries. Then it also provides for disabling access to certain users in case of violation of particular law. And lastly, the grievance redressal mechanism under the for these intermediaries under the IT rules. Okay, second part is for the significant social media intermediaries. And as I said, the responsibility of social media intermediaries are much more. They are required to appoint a chief compliance officer, which needs to be a key managerial person, then a nodal officer, and then a resident grievance redressal officer. Now, what are the roles of these three? First is, and this is something new, this was not there in 2011. So a chief compliance officer is a person who will be ensuring day-to-day compliance of that particular intermediary with the laws of the land. The nodal officer will be the person of contact for any governmental authority to get in touch with the particular intermediary. And then the resident grievance officer who will be taking care of grievance on a in the grievance redressal mechanism, which is with reply to the particular aggrieved person within 24 hours, and then dispose of complaints within 15 XYZ. All these duties were bestowed upon these three officers. Now, this is exactly where Twitter and government didn't go along, because Twitter didn't want officers or still hasn't appointed officers at for these functions, and this is the reason why Twitter has lost its protection of being an intermediary and exempted from Twitter has basically lost its protection or safe harbor that is, it used to get under the IT, Section 79 of the IT Act. Second thing is the compliance report. As I told you, the intermediary, so significant social media intermediaries are required to publish compliance report on the on its website. And then the third thing is identification of first originator of information. Now, this is important for when it comes to intermediaries like WhatsApp. They are, if the government requires them, then they are required to trace down the first originator who had started this who has started this kind of a particular kind of message which has been deemed as fake news or any other illegal content. Now, whilst many of us must be skeptical that the kind of information that or like what kind of information the intermediary is required to pass on to this to the government when it comes to identification of first originator, let me tell you that adequate protection has been built in into the rules itself so as to ensure that no one's privacy is unnecessarily breached. Like, the social media intermediary is only required to hand over such information which pertains to the first user. No other information about no other person is required to be handed over to the government. No other information of that particular person should also be given other than the message that the government believes is violating of the law. And lastly, if the person is located outside India, only the person who is in India will be considered as who has started distributing the information will be regarded as the originator. And then there is the voluntary verification mechanism. Okay, so now getting a little bit in detail into the voluntary verification mechanism. That is, the social media intermediaries is required to verify if the users are original in order to take out this as a crackdown on fake accounts and uses of fake accounts to spread disruptive information, etc. Then again, the grievance redressal mechanism of significant social media intermediaries, and lastly, removal of or disabling of information, like any other form of any other form of intermediary that is required to have a grievance redressal mechanism. Then we come to the intermediaries which are categorized as OTT platforms or curators, something like a Netflix or a Z5 or a news aggregators and current affairs managers. They need to follow some sort of code of ethics and ensure that the particular entities are complying with the code. Okay, now we come to the robust grievance redressal mechanism that has been put in place for OTT platforms and news. The first is the self-regulatory model. Self-regulatory model means the particular entity will have its own in-house grievance redressal, and if it is not resolved within a particular period of time, then the aggrieved person has the right to, say, 15 days or something. The person has the right to move on to the second level, which is like an independent self-regulatory body, like what we have as on date, to draw parallel, say, in Advertising Council of India, ASCI, or something like that, where a body will be set up and the particular body, independent body, will determine the grievance, and they will have a grievance wing and they will determine the grievance. And the third level is the okay, and this particular body has to be registered with the Ministry of Information and Broadcasting. And the third level is the direct interdepartmental committee set up by Ministry of Information and Broadcasting, which will oversee the grievance redressal mechanism. And lastly, that the last part of the rules, which says that all news portals that operate in India are required to be registered, and information regarding these news portals are required to be shared with the Ministry of Information and Broadcasting. So the first and the second part, that is dealing with intermediaries and the social media intermediaries, still here
it is governed by Ministry of Information Technology, and these three parts are to be determined by, uh, they are governed by the Ministry of Information and Broadcasting. Okay, here's the pro tip. Do not read the rules standalone, because these rules go hand in hand with a lot of other laws in India. To begin with, it is in consonance with the SPDA, the Sensitive Personal Data Information Rules. It is in consonance with the e-commerce rules under the Consumer Protection Act. So you have to read all these laws in tandem in order to understand how that entire thing plays out for your for a client who's an intermediary. Best way out is to prepare a checklist of items as a compliance and see if there are any common compliance ground. Like having a terms and conditions is a common thing between the intermediary guidelines as 2021 rules, and at the same time under the e-commerce rules. Also, having a particular having a privacy policy is a requirement under the rules, as the sensitive personal data information rules. So there are common compliance requirements under the law, and it is better if you prepare a checklist. Some new and interesting things have also been introduced, and you should be aware about. First thing is that the cases that we were dealing with, which we discussed a few minutes before, about taking down, proactively filtering and taking down, put it to the laws, so that there is no ambiguity as to what kind of information needs to be put down. Then these monitoring requirements are required to will now also require human intervention, so to see that unnecessary information or free speech is not hindered, or unnecessary information is not taken down. So a lot of interesting changes has happened, and when it comes to these intermediary laws, and it's a good read. You should really start before starting as a practice, go line by line on the law, and get an in-depth as to what changes has taken place from 2011 to 2021 rules, and then accordingly guide your client as to how to go about it. Twitter case, as I had briefly touched upon, is where they are having a dispute, is that Twitter doesn't want to appoint those three. Being a significant social intermediary is required to have those three officers: the chief compliance officer, the nodal officer, and the grievance redressal officer. And interestingly, Twitter didn't want to appoint any of them. And when it was pushed to do so, it had quite funnily given the address of a particular law firm in India, a renowned law firm. And and the government again pulled up Twitter for that, saying that the law clearly says in so many terms that it has to be an employee of yours. So a law firm cannot be your employee. So Twitter, end of the day, lost its protection under the IT Act. And now every case where the Twitter platform is involved against any person, Twitter again is arraigned along with it as a co-accused. And that is exactly what is happening with Twitter. And Twitter itself is sounding like it's a flag bearer of freedom of speech and expression. But if we read the law, the 2021 rules, it has clearly laid down categories or the basis on which information is required for an intermediate to be taken down. And it clearly says that it has to be, information will be required to be taken down only when it affects the security, sovereignty, and integrity of the state, for friendly relation with foreign state, public order, decency, morality, in relation to contempt of court, defamation. So grounds have been clearly laid down as to when an information is required to be taken down. It is not really freedom of speech and expression it is affected. It is not really privacy of a particular person is being affected, because the laws are quite clear on it. However, yeah, what I will agree with is that it should be ideally coming from a court, but the law says that even a particular government body or appropriate agency of the government body can also ask social media intermediaries to take down messages.
Twitter as an organization was not comfortable to adopt the IT rules for the longest time, the new intermediary rules for the longest time, because they were because it exposed them to several liabilities. Also, there was a lot of hesitation internally within Twitter to appoint the nodal officers and grievance officers because there is a liability attached to the individual in case of any non-compliance. And as a platform, the argument Twitter always took to the Indian government was that it is practically impossible for them to regulate content because they cannot have access to real-time verification of what is uploaded and what is shared by which person. Finally, and I'm sure all of you have seen this development in the news until last week. Finally, Twitter, it went to almost a stage where the government was ready to throw Twitter out or even cancel Twitter for their operations in India. Finally, Twitter has agreed to comply with the rules. They are in process of final stages of appointment of a local employee or an officer who will be the nodal officer and the grievance officer who will be responsible for all the actions. But they've obviously sought for some time to fully comply with the regulations. Uh, Facebook, YouTube, etc., have all fallen in place and they have agreed to comply with these requirements.
Yeah.
But the idea is that some of these larger organizations are trying to use their muscle and trying to fight for their independence, where they want to pretty much just be platforms and content sharing platforms versus take on any liability for any content that is being uploaded which is not created by them. So if you all have followed what is happening in the US, for example, when the elections were going on, even after the elections, Donald Trump's account, for example, was cancelled, because, he made certain remarks which are against, the state policy, etc., etc. So in developed countries, it is fairly common to have regulation around the way social media platforms actually function. For example, countries like China, Russia are far more restrictive. India, because historically it's been a democratic
Thailand for that
country.
matter, Jayesh.
Yeah. So India, for example, largest time it's been a democratic country and it continues to be a democratic country. It is in fact one of the world's largest open source platform driven countries. So platforms have taken advantage of this, corporations have taken advantage of this, but the government slowly realizes that there is an urgent need to now start regulating this because a lot of the far reach and the volume that they have, I don't think the government also anticipated that the acceleration would be so quick. And obviously now because of the pandemic, it has just increased because digital penetration is just increased. So in future, one can expect the regulations to get a little more stringent, more accountability. That is the whole idea behind these regulations. And the government is, at least the central government is not taking a soft stand around this. They're very very certain that they want to hold them accountable. They want some sort of accountability for these foreign corporations who are operating in India, and they don't want to have them scot free, basically.
Yeah. So that is that. And so Jayesh, we have seen some fantastic errors in the process. So Twitter was asked to appoint a grievance person or a nodal person, and it had apparently given the address and of contact details of a person of a law firm in India. And it was
Yeah.
hilarious. So this is where faulty reading of law comes in, where the rule specifically state that it has to be an employee of Twitter. Somehow Twitter got the idea of giving the contact details of a law firm. So yeah. So see, end story. The conclusion of the story is Section 79 of the rules doesn't prescribe any penalty. It is giving protection, but if you don't adhere to it, that protection falls away, and then you are exposed to every kind of liability, and that is exactly what has happened with Twitter. So let's see how the end outcome is.
what are other social media intermediaries doing? So if you see, Google and Facebook have already started complying. Netflix, although there is an ongoing case on OTT regarding OTT platforms compliance, but Netflix has, uh, on open media, have declared of its intent to comply with the law. And why not? Because see, countries or European unions or all these jurisdictions which have more robust freedom of speech and expression laws, the laws are still much stricter there. And these particular same social media intermediaries are, when they are operating there, they are readily complying with such requirements. But when they come to India, they want a free gate pass, to not comply with it, and flaunt their non-compliance like Twitter is doing. So I don't see anything wrong as to why a law of a land, no matter how strict they are, shouldn't be complied with. Like there was a point of time when they had their own free gate pass into not complying, because there was no such stringent laws in place. But now when there, I don't see any reason, as and which also gives adequate protection to your privacy, and also the freedom of speech and expression is taken care of in line with the constitution. Then why not comply with it? And some of the small homegrown enterprises, the Coup app and all, they have already complied, and they are already publishing compliance reports. So what's the deal with big companies? Why can't they comply with it? Keep an eye out. More legislations of similar nature are about to come. We already have the e-commerce amendment rules in pipeline, and similar legislations will be coming. Like we're still looking forward to the data protection bill to be enacted into an act. Keep yourself updated, give your client updates, and by giving updates, I mean give relevant updates. Don't just do a data dump on them. You remember, whenever a new law comes in, if you can explain it to them that what implications will have due to non-compliance. For example, take this IT rules 2021 only. If you can explain to them that what happens if the protection falls. See, IT rules 2021 will not prescribe a penalty. It does not prescribe a penalty for if you're not complying with it. It is only when you don't comply with it, what happens is you lose the protection of an intermediary or a conduit, and then you become a party to that particular crime, which is happening over your platform. And then what happens, you become a co-accused. So you have to explain it to your client in simpliciter terms that what happens when you don't comply, and accordingly you'll realize they will also agree with you and be in consonance with you on the implications. That's it.
So I just wanted to ask that when Government of India approached Twitter, they had taken this defense that these rules are directory in nature, not mandatory.
Correct.
So like,
So
so are these rules mandatory or directory, sir?
No, as I said, see, you may choose not to follow, but then you have to be ready to face the consequences, because the safe harbor protection falls away.
But technically, it is mandatory.
The reason why they made
because
this statement.
I mean, effectively, it is mandatory because none of the organizations or portals would want to expose themselves to criminal liability, or to that matter, sort of move away or have cancellation from India. So the government has positioned these rules in a way that they have to fall in place and comply. So it is to that extent mandatory, one can say.
And to that extent, you can even get blocked under Section 69. The block also come into the picture.
Yeah.
Suppose I want to practice IT law in India. So is there any specific course that I can do regarding data privacy and IT law in India, or even online?
Yeah, there are certain, I would suggest that there are two ways you can do it. You can either take up those European Union courses of CIPP and CIPM. You can look it up on the internet. But there is also an Indian version of it, Indian Council of Privacy, DCPP. DCPP and has its own courses. You can take it up. They fairly will give you a good idea about data privacy laws, and you'll also become a privacy professional.
There are also, you should check out some of the universities in India, for example, National Law School, Symbiosis, for example. A lot of these have certification and diploma programs in specialized courses like merger acquisition or taxation or information technology. You can definitely look at one of those to equip yourself further. But as a specialization, you would probably have to learn on job, or you'll probably have, once you start practicing it, will really, that is when you will get experience of it. But there are very limited avenues, at least in India right now. Like Supallab said, you could explore some of the uh, options available globally. There is also, I believe, an LLM that is available, but that's not in India. It's again globally, which is available for data protection and IT.
Yeah.
So these nodal officers are basically the contact point, like these various officers, redressal for the chief redressal, like
Correct.
the complaints and all these nodal officers. So these are
Correct.
basically the contact points wherein the government authority, if they want to investigate, they can contact them. And we
Yes.
as users, if we want to register a complaint, we can directly contact them. So is
Yeah.
this the
No,
like
so
is
see,
this the
the
whole reason?
functions are quite clearly distinguished. You will take your complaints to the grievance officer. The government will contact the nodal person for any kind of information regarding any user or any content. That is the function of a nodal officer. And lastly, the chief compliance officer will be arraigned for any legal proceedings. Yeah, continue.
Okay, sir. So basically, they are contact points for the governments as well as for
Correct. Correct.
individuals like us.
Correct.
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 Okay, sir.
Correct.
Thank you, sir. Thank you.
Okay, I have one question in front of me. Sir, how
Yeah.
is Google a social media intermediary when it is a search engine?
So
Technically, it is an aggregator, right? I mean, effectively, what Google does, it's an aggregator of
yeah,
information
it
that
doesn't
that again
generate any
is,
information.
it does not, it's not the content creator. So if you search something on Google, it is effectively going to put up in sequence or priority content that is already created by third parties. So for example, let's say if you Google plea, for example, it will either shoot up your website, which is not something that Google has created, but in sequential, through algorithms and filters, what it will do is it will aggregate the third party content and just give you the content in sequence. So technically, to that extent, Google also becomes intermediary because it is displaying, it is becoming a platform where this information is going to become accessible.
Okay. The next question is, sir, are the rules stringent according to you?
Yeah,
No, in fact, in my view, my view is a
Suplab
little
said
different than
yeah.
Suplab's. My view is a little different than Suplab when we have our arguments on this. I think they're fairly liberal. When you compare this to a lot of other countries, they're fairly liberal. Because it again is a largely a self-regulatory mechanism versus government intervening in what content is being uploaded, what content is being, which is again the case in countries like Thailand, Russia, China, where websites where government has strict control on everything that's uploaded. That's not the case here. What effectively the government has done by these rules is have platform operators choose and distinguish what content should go up and what content should not not go up in the due diligence process that Suplab just discussed. So it strikes a good balance. It's just that it's a change, and like any other change, content operators and platforms are not averse, or they're averse to it. But it strikes a balance in my view, because it's very important. Otherwise, there is no regulation around these, around the content that is put up, and it could have significant consequences.
Okay, Suplab, your view?
my view, see, agreed, it is less stringent when it comes to countries like China or Thailand, but definitely the rules are robust and and quite apt to the situation that we are dealing these days. I mean, it's actually need of the hour, to be precise. And
Okay.
yeah, they're stringent enough to handle situations which is for which it is created.
But it's important as well, right, Malvika? For example,
Yeah,
today
yeah, yeah,
someone
definitely.
today if someone is seeing content, let's say on their cell phone or on their iPad, or just streaming on the web, it's very important that that content is regulated, because it's not certified. Let's take an example of a newspaper, right? For example, a newspaper, there is an editorial team which vets the authenticity of information. Then it goes through several levels of checks and balances. Today, as a platform operator, just because they are providing a medium, anyone and any person who creates some content can put it up without verification whether that information is authentic or no. That is the biggest challenge, and there was a need to regulate that.
Yeah, because nowadays, if you see, for my mom or my uncle or someone, people from even my age group, also, news is not what comes in the newspaper these days. News is what comes in their WhatsApp forwards, and that was creating a lot of issue actually in India.
Okay. There's one question. What platforms can we use to keep ourselves updated?
Okay,
In terms of
so
law, in terms of law,
subscribe to
in terms of
Medianama.
law.
Yes, I think so.
I mean, I think the person is asking about technical laws. So I think Medianama is a good platform. You can subscribe to that. Then there's the Wire.
Live law is a
Live Law
good
is
platform.
also a good place to get yourself updated, keep yourself updated. But most importantly, if you keep track, or once you're into it, you will come to know a lot of legislations, a lot of developments, and you don't need to visit any particular platform. Maybe your LinkedIn profile can show you that this people will post that this new development has occurred or something like that. Keep an eye on Meaty website. A lot of development is happening over there. Certain websites, for that matter.
Ideally,
Certain
Ministry of
website is
Information
very
Broadcast.
interesting, by the way.
Ideally, Ministry
Sorry,
of
you
Information
Jayesh.
Broadcasting. Yeah, ideally, all ministry websites should ideally be the first source of information, because that's where the rules, notifications, FAQs, and most of these websites also have stringent FAQs and detailed FAQs in place. Obviously, then if you want to have author views, you could, like I was saying, you could look at independent websites like Livelo, Mondak. There are several others, Corporate Law Blog,
Yeah,
but those
we
are again
shouldn't
author
be.
views. Yeah, you shouldn't form your opinion basis those, because those are independent views. Obviously you should rely on something that is being put up by the government, because the interpretation could vary. But as a starting point, I would suggest the government websites or the source are important.
No, I was saying that how important it is to follow the government website. So people have always advised others that there is no there's no data breach intimation law in India. That means whenever there's a breach, you don't need to tell people. But suddenly, Certain has come up with a good practice notification. It's not even notification; it's a good practice memorandum advisory. And in one of the clauses, Certain has mentioned that whenever there's a data breach, you need to inform people. So, stay put to these websites. Meaty, Certain, MIB, Press Information Bureau, to keep yourself updated. There's just no end to the number of things that you have to keep tap on in order to keep yourself updated.
Okay. The next question is, sir, WhatsApp has argued that right to privacy is being violated if they comply with the new IT rules. Your take on it?
No, see, we always find the social media intermediaries locked horns with the government as if they're fighting for a freedom of speech and expression. That is not the case. Firstly, because most of the time what they want that more users to get involved. While I will say that, as I've already told before, that appropriate checks and balances has been kept so that no one other than the person who's the first originator's other person's information is not handed over to the government. That particular checks and balance is there. Secondly, no other information of that particular first originator should be given other than what is being in question. So I think the law does put in place appropriate checks and balances on the privacy, and there is nothing wrong with decryption. Actually, end-to-end encryption is creating more problem rather than asking an authority to decrypt, because anyways, decryption is possible through hacking, and anyone who wants to do it can do it. decrypting for the government will not additionally create any sort of problem to your privacy. That is completely, what do you say, WhatsApp universities then, but no violation of privacy happening because of decryption of your end-to-end encryption.
Yeah, and also I think, I mean, look, as organizations, they are going to take that view that it is violating fundamental rights under the Constitution. But you have to understand that the Constitution, while it provides fundamental rights to citizens and individuals, they always come with caveats. So as an organization, platforms like WhatsApp, YouTube, Facebook cannot directly take the benefit under violation of fundamental rights, because there are very specific rights that are given, and they're always given with caveats.
The next question is, will the compliance officer be criminally liable?
Yes,
It's
in
not.
case of violation, yes. In case of
Yeah,
violation,
but
yes.
again, there is a the proviso which says that it will be taken into the consideration that the social media intermediary is given an opportunity of being heard, and that is provided in the rules actually. And by way when the legislation is saying that it will be given an opportunity of being heard, it means that that particular intermediary can show that it has shown due diligence and taken all actions
Mhm.
that it gets
This,
that protection of a safe
this was
harbor.
one of the reasons. This was one of the reasons Twitter was not comfortable because of the criminal action. Twitter was not comfortable at all to appoint a grievance officer or a compliance officer for this very reason. But again, the question comes around accountability, and eventually, so first they had appointed a foreign national as the grievance officer, which is again against the regulations. The regulations require you to have an Indian resident to be a compliance officer. So eventually, they managed to have an interim. They managed to appoint some interim Indian as a compliance officer, and the reason they were worried about was for the whole criminal action that the government could take and go after, right? But yes, there is the compliance officer is criminally liable in case of any violation.
Okay. The next question is how to learn about the contractual liabilities that need to be followed by these intermediaries. The participant says he's interning.
Yeah, I mean, contractual liability again depends on contractual liability between whom, right? There are several contracts that in the universe of this whole gambit of IT rules are done. So there is one contract between a WhatsApp and the user who's on the platform who has a WhatsApp account. There is another contract between the end user who's streaming it, and then there's a third contract, that the obligation largely that the platform has towards the government. So there are several contracts in each of these. So for example, if a person, if you have, everyone now gets a user agreement or privacy statement that WhatsApp or Facebook or some, most of us don't read it. It just goes on our phone and we just agree and move on. But WhatsApp can technically, it is a contractual breach if a user of a WhatsApp does publish fake news or any obscene material or material which is violating the fundamental rights or protection of India. WhatsApp could terminate his account and also take criminal action or contractual breach action against that particular individual.
Yeah,
Okay.
and if you really want to learn about how to do it, suggest that best thing is to go back to the law for privacy policy, take up the SPDI rules 2011 for drafting terms and conditions, go back to the 2021 rules of intermediary liability, and draft it accordingly. That's the best way you can learn about this. Read all these rules in
Yeah,
conjunctions, come up with.
because the participant is an intern, the easiest way to do it is just to read a privacy policy of an Amazon or Flipkart or even WhatsApp online. Just go online and pick the privacy policy, read it end to end. At least that's the first step to start. And then obviously, like Supallab said, it could be read along with the rules.
Okay. The next question is what are your views on the piecemeal approach to digital laws in India?
I mean, look, it is like I said at the very beginning. It is going to it is a piecemeal approach, but the government is mindful that as the space is evolving, there is need of regulation, and it has to be evaluated on a time-to-time basis. It can't today envisage a plethora of legislations that may not be relevant at this very stage. So the idea is, as and when things become relevant, the government is stepping in and putting appropriate regulation around it. So there is no other alternative other than doing the piecemeal approach, because unlike some of the other sectors, this sector is a very fast-paced sector and evolving on a day-to-day basis.
Yeah. And idea is to create an umbrella legislation always, because the more you get specific into technology, it'll get redundant day after day. We still have provisions for pagers in our IT Act, and who uses a pager these days, right?
Jayesh and Supallab, any closing remarks?
Yeah, just from my side, it's an interesting space. First of all, thank you for organizing this. And if you are a student, if you are someone who is practicing, or if you are someone who wants to learn about this space, uh, keep a track of this space. It is a growing space. It is a space that is evolving, and there are law firms, for example, law firms as well as companies which have opportunities and new positions in form of specialists that are coming up for this very space and this very sector. For example, there are now law firms which have technology teams. There are law firms who have experts in this particular space. So anyone who's interested in this specific area, it's an exciting time. It's a new and developing field, and there'll be ample of opportunities in the coming years. So one could potentially look at this as a career option as well.
Supallab?
I think Jayesh has already covered it. Keep yourself updated and read up more on the upcoming laws, and you might just be able to become a or an expert in these spheres very easily, because unlike Companies Act, or which has been there for years, these laws are fairly new and pretty evolving. So it's easier to catch up and become an expert in. Get started on it. I mean, the world is pretty much there.
Thank
Thanks,
you.
Preeti.
Bye-bye.